Guys.
Yes, Mr. Gotland, we got to injustice to directors is the last thing I wrote down.
My Lord, may I just deal with a couple of matters which arose during the course of this morning's hearing, which perhaps might assist your Lordship. First of all, the rule concerning challenges to admissions of proof is Rule 14.8.
Yep.
And it is limited to contributories, creditors. It isn't extended to directors.
No.
My Lord...
so what about somebody in the position of Mr. Langdon?
Oh.
Unless he can say he's a creditor.
Oh, indeed, my Lord. Mr. Langdon had potentially two routes in. First of all, he would be a contributory. And secondly, Lord, he'd be a creditor. And most directors in liquidations are creditors because of those outstanding wages. Not all, admittedly, but many.
But he wouldn't be a creditor in respect of his personal liability under Section 217.
Well, I was going to take your Lordship back to Elusive and Bake because we skated over that very quickly. And it might perhaps be useful just to look at that again. It's behind tab 7 of the Core Bundle of Authorities. Might I invite the Court to look at the headings of pages 78 to 79?
Yeah. Now, this is one director claiming a contribution against the others.
Indeed so. He having been made liable.
Yeah.
And the key point, as your Lordship will see, is that this was a liability in relation to tax, debt liabilities.
Yeah. So rights of indemnity or contribution in respect of liabilities created by 217 were impliedly excluded.
Lord, indeed. The judgment begins relevantly at page 81, paragraph 20. Paragraph 19, I should say. Page 81.
Yeah.
So in that case, my Lord, the first basis upon which the third party, the claimant, sought contribution was under the Civil Liability Contribution Act 1978. And not surprisingly, at paragraph 22 of the judgment, at page 82, Honourable Judge Pearl QC held that the 78 Act would not assist Mr Yusuf for the obvious reason that the claims in question were debt claims. And then, having rejected the 1978 Act as a basis for contribution, Mr Yusuf sought to argue mere fact that he was jointly and severally liable under 217 would suffice, and Honourable Judge Pearl held that wouldn't work for the reasons stated at paragraph 30 to 33. But it's right to point out to the Court, at paragraph 34, but irrespective of the basis of contribution, whether under the 78 Act or in equity, the Court held that because there would be participation in a criminal enterprise, the company couldn't seek contribution in those circumstances. Now, clearly, my Lord, that was based upon the law of illegality as it then stood prior to Patel and Mirza. But nevertheless, well, that was the decision of Honourable Judge Pearl.
Yes, but it's paras 32 and 33 deal with this.
Yes. That was when His Honourable Pearl considered the basis of contribution on the basis of the Act itself, and only the Act, having rejected the 78 Act as a basis, because...
But transposed to this case, leave aside possibility of unpaid directors' fees or whatever, Mr Langdon would not be entitled to a contribution from the company. Is that right so far?
Well, Lord, on the basis of this case, in particular paragraph 34, that would be right. The difference between that...
Just hang on. So far, on the basis of this case, that's right. So if he's not entitled to a contribution from the company, or an indemnity from the company, he's not a creditor of the company in respect to the Section 217 debts.
No, Lord.
So unless he's got some other debt independently owing to him, he would not be in a position to challenge, under the insolvency rules, the admission to proof by the liquidator of an invoice purporting to record a company's debt.
Not in the 1480 insolvency rules, no, Lord.
Right.
What the distinction between Yusuf and this case, Lord, is that the liability in this case is based on damages rather than debt.
Yes, but we've got to arrive at an interpretation of Section 217 which underpins a rational and coherent scheme.
Yes, Lord.
So, as my Lord Justice Arnold suggested, one way of testing it all is to posit a hypothetical invoice,
Yes, Lord.
as opposed to a judgment.
Yes, Lord.
What mechanism, if any, would a person in the position of Mr Langdon have to challenge the accuracy of an invoice, either as to amount or liability or anything else for that matter?
Well, I say, Lord, in response to Lord Justice Arnold's point, that in that situation there had not been an authoritative determination of the existence of the debt.
Even if a liquidator admits it to proof?
Lord, in my submission, the situation is distinguishable.
So all right, the creditor issues an invoice to the company for £100,000, let us say. The company's insolvent, the liquidator admits it to proof, the creditor then turns around and wants to recover the money, or so much of it as hasn't been paid, from the director. The director says, we never bought the goods, or they were defective, or they didn't cost nearly as much as the invoice says they did. How does can he bring those challenges to the invoice, and if so, how?
He could certainly do so as a contributory or as a creditor.
Right, well, he's neither.
If there is a director who is neither a contributory nor a creditor, and my Lord, in many of these cases which arise under 217, we're dealing with small companies, where of course the director is genuinely a contributory.
What, in a capacity as what, shareholder?
Shareholder, my Lord. But I say in any event, my Lord, all that with respect that the respondent needs to submit for the purposes of this appeal is that a judgment being an authoritative determination as a matter of record, that establishes the liability of a company.
Yeah, I see that, but go back to the hypothetical invoice.
Yes, Lord.
If the creditor wants a record of the company's liability for whatever is shown on the invoice, it would have to get a judgment. But if the company is insolvent, it's unlikely to be able to proceed to a judgment, because the whole point is you submit your proof to the liquidator.
Yes, Lord. Well, there are two possibilities in that circumstance. Either you'd proceed against the director separately in proceedings, in that particular context,
Yeah.
if there hadn't been an authority determination, or the director was generally in a position to challenge the admission of proof anyway as a contributory, insofar as one could rely upon the proof. But I don't need to submit.
So does your submission come to this, that the creditor has to establish by means of court proceedings the liability which he claims, either by proceedings against the company or by proceedings against the director, but he need not duplicate the proceedings
Yes,
by doing it twice?
Yes, Lord.
Either or will do.
Yes, Lord.
But presumably that can only be the case where the debt is disputed.
But if the debt isn't disputed, my Lord, and of course the debt if the debt is submitted by the director, then that would be the end of the matter, my Lord. Of course, the director.
Right. So therefore, a judgment can't always be needed.
Insofar as the debt is disputed.
Yeah.
My Lord, there is another matter which I should bring to your lordship, and that's section 112 of the Insolvency Act, which does entitle a liquidator to apply to the court to determine any question arising in the winding up of the company. So he might, my Lord, in principle, be entitled to challenge the admission of a debt under section 112.
Sorry, would you repeat that in
Yes,
relation
of
to
course.
112? Who has the power in 112?
A director.
Right.
So forgive me, my Lord. I'm entirely my fault. I misheard my solicitor. Lord, no, it doesn't work. I do apologise. I need not repeat it, my lady. I do apologise.
All right.
But what you were just saying was in relation to an invoice, one would have to proceed either against the company or the director.
Yes,
If the debt's disputed.
if the debt's
If the
disputed.
debt's disputed.
Right. And so you're not saying that Yusuf is wrong, that there is no right of indemnity.
I'm saying the
No
law
contribution.
established in Yusuf, my Lord, is that there is no right of contribution. On the basis, at least, of a liability that stands in debt. The position might be otherwise in relation to a liability that stands in damages. Because the primary decision in Yusuf was that the 78 Act didn't apply. If the company and the director are potentially both liable in relation to damages, the position might be otherwise. But, as I indicated to your lordship, paragraph 34, on the basis of law of illegalities, it then stood Judge Pearl, Queen's Counsel, rejected any question of contribution because of a participation in illegality. But, my Lord, fundamentally, my point, hopefully, and I can make a point shortly, is a simple one. If the debt is disputed, it needs to be established authoritatively, either against the company or the director, but not twice.
Yeah.
Well, I understand that, and of course that's sufficient for your purposes, but I'm still trying to understand how logically this works in circumstances, because we're often, not always, but often in these cases, going to be dealing with a situation where the company trading under the disputed name is insolvent. That's not necessarily the case, but frequently that's the factual scenario.
Yes, Lord.
That's the reason why recovery is sought against the director.
Yes, Lord.
So we go back to the situation where the company trading under the disputed name is not merely insolvent, it's in liquidation, it's being wound up. The liquidator has accepted the debt in question, has admitted it to proof. Now, in those circumstances, I think you're accepting that it simply would not be possible to get a judgment against the company for that sum. The whole point being that it's collective execution for all benefit of all creditors, and you've got the moratorium on proceedings, and you'd never get it lifted for that purpose.
You'd certainly need to get it lifted. I entirely agree with that, Lord, and it's unlikely in the circumstances one would get it lifted. So in those circumstances, Lord, one would have to proceed against the director to obtain an authority determination.
Okay.
Right.
At 1 o'clock, your lordship invited me to consider the judgment of Honour Judge Kirkham.
Yes, whether there was any difference between actual part payment and set off.
My Lord, I can refer your lordship back to the judgment of Honour Judge Kirkham herself, who analyses the basis on which she decided that insolvency set-off doesn't apply. That's, my Lord, in the supplemental bundle of authorities.
You are, of course, under no obligation to defend the judgment. It's not binding on this court.
No, my Lord. That's at tab 7, Lord, a supplemental bundle of authorities.
Yeah.
And it begins at page 170, my Lord.
170. Yes.
Paragraph 35 and onwards.
Yeah.
And what she is effectively saying is that Rule 490, the predecessor of the current insolvency set-off provision, only operated as between the company and its creditors, not between the director and the company's creditors, and therefore was no basis upon which the substituted liability of balance for the original debts would affect the director. Rule 490 simply did not apply to the director, and there was no basis upon which it could do so. Rule 490 being confined to the position as between the company and its creditors.
Yeah.
But of course, if the director is a creditor, then that reasoning wouldn't apply, insofar as he's a creditor.
Insofar as he were a creditor, my Lord, he'd be a party to the, and he were asserting his own set-off, Lord, that would be different, my Lord, yes, indeed. Yeah. This is a position where the company asserts an insolvency set-off against a third-party creditor, not the director.
Yeah, all right.
Of course, the other matter, my Lord, I'm not sure how much further this takes it, is that the insolvency set-off applies at the time of the winding up of the company. Under 217, the liability of the director would already have been established. So it would have been crystallised as at that time.
Yes, right.
Lord, I think I had taken Lordship through paragraph 35 of my skeleton.
Yes.
By reference.
Yes.
I'd also invite you, Lordship and my lady, to read paragraphs 36 and 37 of my skeleton.
Yeah. Yes.
And so my conclusions, my Lord, my lady, are set out at paragraph 38
Yeah.
in relation to issue 1. Unless I can assist the court further in relation to issue 1, those are my submissions.
No, thank you very much.
Issue 2.
Yes.
My Lord, fundamentally, the issue which is before the court and was before the court below is the time at which the relevant liability is incurred.
Yeah.
The respondent submits that the relevant liability is the liability to pay damages.
Do you distinguish between the liability to pay damages, the liability to pay interest, and the liability to pay costs?
Well, the liability to pay interest and costs can only arise from a judgment. That's not a point that was taken below, my Lord, but it is clearly correct that it does flow directly from the judgment and can only flow from a judgment, or more precisely from the order.
Yeah.
Essentially, what the respondent submits more is that the relevant liability is that in respect of which the company is actually liable for breach of contract. On the appellant's contention, or interpretation of 217, the director incurs a liability under section 217 before the company could be pursued for any money. In other words, the director would be liable before the company is liable.
And you say that's wholly illogical.
Wholly illogical, my lord. It would be perverse. And one of the matters to which the court can have regard is the perversity of a proposed interpretation of a statutory provision. And we go so far as to say that that would be a perverse interpretation of 217, particularly given the purpose of 217.
So does it follow then that debt in 217 is not to be given the very broad meaning that it has in Rule 14?
I say one has to focus on the relevant liability, debt or liability. And both words are used. And what we say here is there's a relevant liability, and that relevant liability is the obligation to pay damages for breach of contract, which necessarily is incurred at the time that the company acts in breach of contract.
I suppose you've also got a judgment debt, which arises out of the judgment.
Indeed so, my lord. Which again was incurred at a time when the company was, using a prohibited name, successor company.
In fact, I think, so strictly speaking, I'm thinking aloud, am I right in saying that you haven't got a cause of action against the company anymore because it's all merged in the debt, in the judgment, which creates a judgment debt?
Strictly speaking, the cause of action that pre-existed the judgment merges into the judgment.
Yeah.
My lord, Langdon raises three submissions again in relation to the second ground, parliamentary intention, secondary obligation, and the definition of relevant debts, and I can deal with each in turn. First of all, parliamentary intention. As the court will note in paragraphs 42.1 and 43 of my skeleton, it was common ground for the judge that the appellant would only be liable for liabilities incurred by the company after the liquidating company had been wound up, that being the effect of ESS and Sully. Therefore, even if the sole mischief at which section 217 was aimed was the risk of confusion, this would be a non-issue, because it was common ground, my lord. But on the basis of ESS and Sully, only post-prohibited name liabilities would be covered. I also make the point in paragraph 45 of the skeleton that in fact the mischief was wider. Fundamentally, the issue is not whether the appellant ought to be liable in respect of pre-winding up liabilities, but rather when the relevant liability was incurred. My lord, dealing with secondary obligation to pay damages, my lord, the learned judge addressed this at paragraphs 96 to 97 of his judgment.
But if you're right to adopt the suggestion that I put to you, that what you are actually doing is enforcing a judgment debt. Why does it matter whether this is a primary obligation or a secondary obligation or any other kind of obligation? Whatever it was, it's gone because it's merged into the judgment debt, and that is now what you are relying on.
The case has always been put on the basis that for the purpose of 217, there was no merger. There was merger in relation to any cause of action which applies for the company.
Oh, I see. So there's no merger.
But why? I don't understand that, because Section 217 covers, never mind liabilities, it certainly covers debts of the company. And surely the paradigm example of a debt of a company is where there's an outstanding unsatisfied judgment against the company.
Yes, Lord, but that's undeniably the case.
So that judgment debt was created by the judge's order.
It was, Lord. And undeniably, Lord, that judgment debt was incurred at a time when and following the winding up of the successor company.
Yeah.
And undeniably so, Lord.
And it would be the same judgment debt, whether it was the fixed price for the repairs or the damages for failing to do them or whatever else
It would make no difference, Lord.
It still would have been a judgment debt, which was created by the judge's order.
Yes, Lord. The second submission made, Lord, the second obligation to pay damages, I can probably deal with briefly, my Lord. I invite your Lordship very briefly to refer back to 317, which your Lordship can find in the core bundle of authorities, tab 1, page 8. Meaning 217 begins at page 8, 3A, your Lord, is at page 9.
Yeah.
And it refers more to such debts and other liabilities. Well, this is undeniably more a liability. A claim for breach of conduct, Lord, is a claim, is another liability. So irrespective of the definition of debt, this liability was incurred at a time following the winding up of the liquidating company.
So your point here is that since the statute uses both the word debt and the word liability, but the rule is defining debt, the phrase in the statute, debt or other liability, can be given a meaning which differs from the meaning given by the rule.
Wider, otherwise there would be no need for word
I
liability.
understand that. Yeah.
Lord, can I very logic back to the judgment of the Lend Deputy Judge? Core bundle, tab 5, paragraph 97, page 66.
Yes.
I just invite your Lordships to read 96 and 97, please.
Yeah.
So that was the basis upon which the issue was put. It was acknowledged by my learned friend that the obligation to undertake repairs or procure the undertaking of repairs was not a liability within the definition of the Insolvency Rules 1416. Because it was not an obligation to pay money or money's worth. So at the time the contract was entered into, forgive me, So at the time that the contract was entered into, there was no relevant liability to pay, which fell within the definition of 1416, save for, on my learned friends analysis, a contingent liability which would not found a cause of action or claim against the company. And given the purpose of 217, which is to enlarge the range of potential persons who are liable for an existing liability, we say that would be a perverse interpretation of 217.
I'm sorry, Mr. Langdon, can you say that again? So you're saying when the contract was entered into, there was nothing but a contingent liability.
There could be no other liability other than a contingent one. A contingent liability in the sense that, in the event that there were a subsequent breach, that would give rise to a secondary obligation to pay damages.
Yeah.
It's an unusual use of the word contingent, because, I mean, in that sense, every contract in the world contains a contingent liability, because any contract may or may not be broken.
Precisely so, my lord. That was my next submission. It's such a meaningless use of the word contingent liability, as your lordship Arnold correctly points out with utmost respect. If my learned friend's analysis is correct, that every contract creates a liability to pay money or money's worth at the date on which it's entered into, even though none of the primary obligations involves the payment of money.
Yes.
And of course, it's right to note, Lord, that this contract did not involve, as I say, the payment of money. This isn't a claim where, for example, your lordship postulated a claim in which there were to be payments by instalments over a prolonged period of time. In that case, my lord, there was at least potentially an obligation to pay money accruing in the future. In this case, there was no obligation to pay money unless there was a breach of a primary obligation.
Yeah.
Well, I deal with these matters at some length at paragraphs 47 to 54 of my skeleton argument.
Yes.
The only matter which I would like to elaborate upon, my lord, two matters, my lord. First of all, my learned friend referred your lordship to the Millwall Football Club case, and my lord, I don't intend to do this at any significant length. The important thing to note, my lord, is that this was a case involving a CVA.
Yeah. Does that make a big difference?
It only makes a difference to this extent, my lord. What the court was concerned with in that particular case was the true interpretation of the provisions of the CVA. It has no wider significance than that, my lord. And your lordship will see the question involved the definition of moratorium debt. That's at page 457, letter H, page 227 behind tab 13 of the supplementary bundle.
Page 227, you say? Yes.
227, Lord, letter H. So there was a definition in the CVA of moratorium debts. And the issue was whether or not the liabilities in respect of which the creditor was claiming fell within that definition.
What's the record date?
I think that's. I'd have to put the authority. I think that's the date.
30th of January 1997.
Yes, Lord.
So Mr Hortop had a contract of employment
Yes, Lord.
with the football club, and that contract was terminated on the 10th of February.
In effect.
That is to say, after the record date.
Yes, Lord. And what the court concluded in that case is based upon the interpretation of moratorium debts.
Yeah.
His claims.
The claims were for monetary amounts due under his contract of employment. So it was lost salary, pension, car, medical insurance.
Indeed, so, Lord.
So these were obligations to pay money.
That was my next point, Lord. Indeed, exactly so.
Yeah.
Which, so, in other words, they came within the definition of liabilities as defined in moratorium debts. And indeed within 14.16 they would. Because they were an obligation to pay money or money's worth. But fundamentally, Lord and Lady, I come back to the essential point that one needs to give Section 2173A sensible construction, one that is in accordance with its purpose and does not yield improbable results. And on that basis, what the respondent submits is that the court is concerned with actual liabilities, liabilities in respect of which a claim could be made against the company. And that follows not just from 2173A, but also 2172. 2172 is the provision that renders the director jointly and severally liable with the company. But we say, my lord, that that is nonsensical if the effect of 217 is to render the director liable at a time when the company itself is not liable in relation to the relevant liability. And of course, context is everything, my lord. And your lordship would be well aware that in relation to the presentation of a statutory demand, the word debt is qualified, so it has to be due in order for the statutory demand to be presented. And I refer to the decision of JSF Finance, but it's well known, familiar law. My learned friend's submission I'm following your lordship's note. My learned friend's submission relies upon a very wide definition of debt, the intention of which is to enable a creditor to prove in relation to what might, on a layperson's interpretation, not in fact be a debt, but in order to be able to prove in the insolvency, in other words, to widen the field of potential creditors. For the obvious reason that if a company is about to be wound up, the only possible means by which a creditor of a company can obtain recompense would be to prove in the insolvency. So he's using a definition, if the intention of which is to widen the ability of a creditor to prove, to narrow the potential range of parties liable under Section 217. And we say that's also a perverse consequence of my learned friend's interpretation. Well, the third submission maybe my learned friend is in relation to the definition of relevant debts. And Lord, I address those matters in paragraphs 55 to 57 of the skeleton argument. And I refer to the judge's learned judge's own decision at paragraph 99, where the judge noted my submission.
Yes.
My learned friend flagged up paragraph 103, and he suggested, and this is page 67 behind tab 5 of the core bundle.
Yes.
And the judge accepted an anomaly that would follow. However, my lord, on any analysis, the respondent submits that the consequence of my learned friend's interpretation produces a far more anomalous result than that for which the respondent contends. And more importantly, the judge was alive to this issue and correctly decided in our respectful submission, but notwithstanding it, that the interpretation which the respondent proposed was the correct one.
Yeah.
Well, may I just take instruction to one very brief matter? Yes, my instructing solicitor helpfully points out that the particulars of claim in the present proceedings claimed effectively the judgment debted at the end was or alternatively damages, my lord. But I'm not sure that takes matters a great deal further. My lord, unless I can be, my lady, unless I can be any further assistance, those are my submissions in relation to ground 2.
Thank you very much. Do you wish to reply, Mr. Chichester Clerk?
I do, my lords, my lady. Can we just start where my learned friend left off with the liability, the nature of the liability under the contract? Lord Diplock, in paragraph 55 of our skeleton, explains that the liability to pay damages implies by operation of law at the point of the contract. That's the first point. Secondly, yes, it's right. I think the learned judge and I might have been at ship sailing in the night. I accepted that at that point there was no liability to pay money and money's worth, but I wasn't, at least I don't think I was, hope I wasn't, accepting that there wasn't a liability under the contract, because of course there's the decree of specific performance, which would arise immediately. And that's why my learned friend's wrong to say that if the director would be liable even if the company wasn't. It's parallel, must be.
It doesn't matter, but I think you'd be lucky to get an order for specific performance of a contract to carry out ship repairs.
Well, yeah. But there is a potential, but underlying that is the liability to pay damages. Now, which I accept is not a liability to pay in money and money's worth, but we looked at 14.16 and it included a liability in contract as well as debts and liabilities. So the starting point is that it seems to me, and this brings me to the purpose of the legislation, which is this, it seems to us, and why my learned friend's submission is not right, and it's this: the section 216 obviously is a deterrent generally to the mischief of potential confusion for creditors and suppliers of the old company who may be confused. Section 217 is doing something slightly different. It's imposing a measure of liability, but it is limited in certain ways. And it's limited in two ways. The first way is it's limited by the time that the director has been involved in the management of the company. But now we know from Sully, and we must read in, it is also limited to periods in which he was he or she was in contravention of Section 216, acting in contravention. We know that it goes further than the Phoenix type situation to confusion, and it must be potential confusion that is caused to creditors and suppliers who are going into obligations with the new company. Now, if, as my learned friend says, it must happen at the point of breach, what that tells you is that it's after the contract has been entered into with the creditors and suppliers. What that tells you is that actually the unpaid debt or obligation for which a creditor is trying to get from the director is attributable not to the use of the prohibited name, but to the fact that they've gone into a contract with a limited company. That's all it is.
Yes, I mean, your point is that at the time when the contract was made, there was no contravention of Section 216, therefore
Correct.
no mischief to be addressed, and therefore no reason to tell creditors anything.
Yeah, what I'm addressing is my learned friend's point that this is absolutely in line with his interpretation, which is breach, which is after the contract, is in line with
that's your answer to a number of the exclusion mechanisms. What's the point of the director giving notice to somebody who's already in a contractual relationship with the company?
Yes.
What are they going to do? So
Yeah.
we won't go on with the contract?
What's the relevant confusion? And more specifically, what's the relevant conclusion in relation to Section 217, which is limited to in the ways that I've suggested? On the question of what my learned friend has been arguing, what the court's been arguing, I mean, the case has been put all the way through on the basis that the relevant obligation is the liability to pay damages, and that's there we are. I make that point. It's not open to him now. But leaving that aside, what have we got? We've got, if the cause of action disappears, we've got the judgment debt, my lords. I came under fire earlier for bringing up the idea that people were arguing Hollington.
People were what?
People were arguing Hollington and Hewthorne
Yes.
back door. Seems to me that's where we've got to actually. The way the order on its face talks of the payment of sums, but it doesn't tell you any more than that. It doesn't tell you about relevance. It doesn't tell you when the debt was incurred, in what circumstances, what kind of debt it was, what kind of liability it was based on. At which point, my learned friend starts saying, well, you have to look at the other documents. And in the context of this case, of course, you have to know what kind of liability or obligation is in order to know whether it falls within the scope of 217, because that's limited, as I say. So you have to know facts. And at that point, what he's saying is, right, now I go to the judgment, and that tells you the basis of it. And now we're into Hollington and Hewthorne. That's exactly where we seem to have ended up. And I was thinking about this. I mean, when somebody says you establish it by a judgment automatically, what really he's saying is that the judgment is conclusive evidence. There's another way of saying it, which is why I said at the outset I thought that maybe that was another way of looking at the case that's being put against me, and it's just wrong. He cannot, the moment he says, right, I have to go and find out what this debt is, liability is, we are looking at him saying, well, actually, I'm looking to the findings for the legal effect and possibly the factual findings as well.
Can I ask a question which is relevant both to the point that you're now making and to the point you made a moment ago? Because if we look at the particulars of claim
Yes.
in these proceedings,
Yeah.
which we find in the supplemental bundle at tab 5, starting at paragraph 29, and I can pick it up at page 33,
Sorry, I picked up the wrong. They're both called the same thing.
Supplemental bundle?
Yeah, I picked up the authority supplemental bundle.
That's all right.
Sorry.
So tab 5,
Yeah.
picking up particulars of claim at page 33,
Yes.
and it starts at paragraph 22. Mr Justice here gave a judgment, and then the involvement or otherwise of the defendant is addressed in 23. And then what's pleaded in 24 is pursuant to the order of Mr Justice here dated 1920, company was ordered to pay the following sums to defendants, and then those are defined as the settlements. Then you've got the judgment sum, interest, and so on costs at D. And then it's pleaded judgment sum continues to attract interests, no appeal, and so on and so forth. And then at 30, sums remain outstanding.
Just pausing a moment, what has been assigned, paragraph 27, is the judgment sum, not the course of action.
Yeah, as my Lord rightly points out. And then the summary at 32, pursuant to the above matters, the defendant is indebted the claimant in the sum of. So it is squarely pleaded based on the order, not upon any underlying cause of action.
But in order to work out, for the purposes of section 217, whether you fall within it, you have to show that you're within a relevant debt liability. We know that that is limited. It's limited by various things. If it falls within 41(1)(6), as we looked at, that's one question. But another question would be, when was the contract upon which this is based, because there's no debt without a liability on an order. You are faced with this piece of paper which just gives you figures. You inevitably have to go back to the pleadings, and once you're into the pleadings and the dispute on the pleadings, then you're into the question of what the judge has said. And that's exactly what's happened.
Well, are you? I mean, looking at the underlying facts, they are, in this case, agreed. There's no dispute about them.
For the purposes of the preliminary issues. But they're not agreed in terms of the liability, no.
Oh, I see.
No. I'm sorry, my lord, I did say this.
I had understood they were agreed facts.
No, sorry. They are agreed facts, but the question of whether there was a contract at all is certainly not agreed.
Right. Perhaps you should better show us what the terms of the agreement were, because I haven't picked that up.
Yeah. No, absolutely. I mean, I don't think my learned friend would, for a moment, depart from that. No, the preliminary issue is on the hypothesis. That's probably the best place to go, actually, which is the...
Right. Is the order, is this Master Bowles' order?
Yeah, if you...
got that somewhere?
It's repeated in the judgment itself, probably.
It's tab 11, I see, in the supplement.
Oh, thank you.
I see. An agreed or assumed statement of facts.
Yeah.
Yeah.
And the preliminary issue says...
Sorry, wait.
In terms...
And the agreed statement of facts, as I understand it, is tab 15, is that right?
Yes. It is not.
So these are not assumed facts. So what the recital tells us is that these are agreed facts solely for the purposes of determining the issues. Neither party shall dispute any of the following facts in connection with such issues, but shall be free to do so in connection with any other issue that may arise.
Right, all right.
Yeah, I mean, sorry, this is... when we were going through the facts, my reference to the assumed date of the contract was on the hypothesis and without prejudice to our clients. Yeah. So they're absolutely not agreed. And if you want to find out whether the debt or liability the underlying debt or liability. And
But I'm sorry, I don't understand this. So look at paragraph 6
Sorry.
of the agreed statement of facts. So this is supplementary bundle tab 50, page 134 in the bundle. And it says, on or about 21st of October, Mr. France entered into a contract with DYSL for the purchase of a yacht known as Elusive, and that's then defined as the agreement, purchase agreement. And then we get various other matters. So these are the facts that are agreed for the purposes of the determination of the preliminary issue.
My lord, I may be misunderstanding. The contract that I'm talking about is the alleged oral contract which predated the use of the prohibited name in September 2017. That's not the purchase agreement. The purchase agreement, and that is totally agreed, was the agreement between Mr. France and DYSL, which was the sales.
Yes, I apologise, I was mixing up.
No,
yes, thank you for the clarification.
No, I'm sorry that.
It's the oral agreement, which is alleged oral agreement.
Yeah,
put it that way,
which is hotly disputed.
which is disputed.
And if you look, maybe it doesn't matter for the purposes of the appeal, but we'd respectfully say that the basis on which it was pleaded and also the findings are, with respect, fairly thin to non-existent. One of the grievances that we've got tears over on this side for a while. And that's part of the problem with this, is that, if my clients...
Yes, I'm sorry to interrupt you, but I'm still confused. And
Indeed.
I apologise if the confusion is entirely my fault, which it may be.
No.
But what we find going on in the agreed statement of facts is, for example, at paragraph 36, we get recited the contents of Mr. Justice Tier's judgment, and then we get recited the material terms of the order in paragraph 37, the fact that the company didn't appeal, and so on. So, absolutely, I entirely understand that the allegation of the oral contract was made in proceedings to which your client was not a party, and he's been held not to be a privy, and there's no appeal against that finding. So therefore, of course, you're absolutely right. You've never admitted, your client has never admitted the oral contract. But that's not the question, is it? The question is, how does one assess relevancy? So we have a judgment of the court, an order establishing a debt against the company, and that's not in dispute. So then the only remaining question, subject to the point that underlies ground one, is how do we establish relevancy? To which the answer is, we can establish relevancy by reference to the agreed statement of facts.
But if those are disputed, if my lord's is asking me why is it relevant to look at the order, why is my lord saying that it's not relevant what the oral contract?
No.
Okay.
So one has to distinguish between the question of what is admitted with regard to the facts underlying the claim made in the commercial court, as to which your client has never made any admission whatsoever, never having been a party, etc., etc. And then the question which was the subject of the preliminary issue, which is what is the effect, for the purposes of the Section 217 claim, of the order made.
Yes.
And the statement of facts were agreed for the latter purpose.
Is it, I'm sorry, I'm just being a bit dull here. So just say that part again.
Can we just look for a moment at page 67?
Yes.
This is the order.
Sorry, page 67.
67 of the supplemental bundle. And the
Yes.
question which the deputy judge was invited to consider was whether your client is personally liable under section 217 the debt alleged to have been incurred to the claimants, well, actually not the claimants, to their predecessors, by DGL, if and on the footing that, in September 2019, DYGL entered into an agreement in respect of repairs to the yacht. So that's embedded in the order.
I see. I'm sorry. I'm beginning to see where we
can't say in this appeal this contract was never entered into in 2017 because that's the basis on which the
in relation to the relevant debt issue.
Yeah.
Yes. Yes, I have to accept that. Yeah. But not in relation to the first issue.
No, that's independent.
And that's what I was. That's where my Lord, Lord Justice Arnold and I were at odds. Where I didn't understand. But yes, no, that's correct. That is absolutely correct. It's on the hypothesis. I'm so sorry for going down that rabbit hole, but I didn't appreciate the point. But yes, I mean my point in relation to the raised judicata issue, etc. I do say it's relevant in relation to that because you have to know in order to find yourself within section 217. And my learned friend says on the first on the automatic liability issue that in order to get 217 you have to look and see what the basis, or what I would say is you have to look and see what the basis of that order is. And the moment my learned friend starts looking at documents for relevancy, that's where Hollington comes in. That's what I was trying to say.
All right.
No, I was the only other point that I was in relation to. I think my lady's point was CPR 40.9. We say that actually it's a wholly impractical way of dealing with the problem. If in practice, what will happen? The only time that a director will know that he is going to be made personally liable, or by either the on the basis either of an adjudication by the liquidator or actually pursuant to a judgment, is when he gets those 217 proceedings on his death. Now, at that point, there may well have been a trial, a protracted insolvency process, the admission of proofs be right at the end. By that time, you have to envisage a director coming to court and saying, a long time after the event, after all of the witnesses have scattered because of the insolvency of the company, no access to the to the witness evidence, no direct access. Just what happened in this case. I've never seen the witness statements.
That cuts both ways, doesn't it? I mean, the same problems beset the creditor if he's got to start all over again.
Well, is that really the case? We would say it may be a little bit overstated in the sense that actually when you've been through it once, you've got your evidence, your pleadings. I accept there will be additional cost and expense for the creditor.
But you were positing witnesses having disappeared or whatever it was. So.
No, but they've had their claim. They've done their claim already against the company. They've marshalled their resources, their evidence, etc., etc. I know nothing about this.
But if they've got to bring another action against you, which is what my Lord Justice Lewison is talking about, then they have the problem just the same as you, that the witnesses will have gone off into the blue yonder.
Well, I say in practice, no, because their witnesses, their pleadings, they've just gone through that process. Whereas we know nothing about it.
on your posited facts.
Yeah, possibly.
Yeah.
I mean, I make the point for what it's worth.
Yeah.
I think. Oh yes, my learned junior reminds me. Just a point of the Millwall case did involve a damages claim based on the termination of his contract, as well as wages, salaries, etc. Just make that point. No.
Thank you very much.
My Lord, your Lordship referred to there being only one assignment of the judgment debt, but was a subsequent assignment, which was the subject of an application to amend, which, if my memory serves me correctly, was never finally resolved because it would only become relevant in the event that we were unsuccessful in relation to these preliminary issues. I
I was just looking at your pleading, that's all.
Well, that's because it's subject of amended pleading,
All right.
which we haven't yet had permission for.
Right, well, thank you both very much for your arguments. We will reserve our judgment. As you might expect, it being nearly the end of July, you may have to wait a while to get the draft, but you will get a draft in due course. That will be your opportunity to correct our English, but not our reasoning. The draft will come with strict embargo, which means what it says. We would hope that in the light of the draft you will be able to agree an order disposing of the appeal. And if you can't agree a form of order, please make short submissions in writing and we will make the form of order that we consider to be appropriate. Thank you very much.
All rise.